Why is it important to have a living trust, a will or testament, or things that you encourage your clients to have? Why is that so important?
Well, I don't know if you know this, but in California, if you pass away and you have an estate that's worth over $150,000 and you leave absolutely nothing behind, then your estate will go through the process called probate.
Right.
So it's a judicial process where it can take up to sometimes 2 years to complete. It's completely public, and it's very expensive. Very expensive.
To hire a probate lawyer.
There's statutory fees that are already assigned. So just to give like a little estimate, I mean, and this is really an estimate. If what you leave behind is worth, let's say, 400,000, you're probably looking at fees anywhere around $16,000.
Mm,
So obviously you're not paying for it because you've passed, right?
correct.
So your estate is paying for it. And if all you leave behind is a home, then guess what? Either it's liquidated or your beneficiaries will then have to pay the cost of the probate
Wow.
process. So it's very expensive, it's public, and it can take a very long time and hold everyone up, right? So you want to avoid that. And you think that by creating what everybody thinks is the right way to do, which is a will, that you'll be fine, right? Oh, we'll just do a will. A will, unfortunately, the way that I explain a will to my clients is I tell them that a will is like a letter that's addressed to the judge, which basically means it doesn't avoid probate. So it just means you're showing the judge your wishes, who you are, what your assets are, who your beneficiaries are, and how you want that to be distributed. But it does not in any way, shape, or form avoid probate. So you're still going to go through that process. So a will, if you have an estate that's over 150, and Shannon, are you a homeowner?
Yes, I am. I bought my home 2 years ago.
So then you know that your estate is automatically in that category, because homes in California, it's very rare you can find a home that's worth under 150,
Oh, of course.
right?
Yeah.
So if you own a home, you're automatically in that category. And if you
And it's
have
well over $150,000.
yeah, so if you did not have that living trust that I prepared for you,
Yes.
then your property would go through
Let's
probate.
go into it because I sought you out. I bought my home mid 2017, and it was my goal in 2018 to contact you and say, Michelle, I got to get a living trust. Michelle, I got to get a living trust. I have all my life insurance policies intact, which is wonderful. I can't be an insurance agent and not have insurance policies. How hypocritical would that be?
Yeah.
But I tell my clients, say, look, you got the first leg up. You got the leg up of life insurance. Now, because I am not an attorney, I'm going to give you Michelle Castillo's name because now you need a living trust. Michelle, why did I make the right decision in getting a living trust?
Because by doing so, you're avoiding the probate process when you pass away.
I'm dead and buried. The worms are eating my body. I don't know what the heck is going on. I'm done. My beneficiaries are my brother and my parents. Now, my parents are not mentally or emotionally prepared to read a 100-page document, but my brother is. So when I did my living trust with you, I made him my trustee, right?
Yes.
Okay. I made I'm telling you so much private information. But
The trustee is the administrator of the trust.
he's the administrator of trust. So you gave me this gorgeous. It's sitting. I'm looking at it right now. This
beautiful
gorgeous
binder.
leather binder. And my brother is my trustee. What does that mean? Making my brother my trustee. What does that mean that my brother needs to do I die?
That means that your brother will administer your estate in the event that you are incapacitated mentally.
Okay.
Okay, let's say you unfortunately get Alzheimer's or
Yes.
anything like that.
Yes.
Then your brother would step in and continue to administer your estate.
Is that power of attorney?
No, that's different.
What's the difference between a living trust trustee and a power of attorney?
So the living trust trustee is the administrator of your estate. That doesn't necessarily mean that they have the power to be able to, act on your behalf. So it just means that they can administer it, right? They would hire the appropriate people to continue making sure that your estate is running like it should be, making the tough decisions that if the house needs to be sold so that you could continue living in that assisted home, then that's what they have to do. So it's a structure for them to be able to make sure that your best interest is always looked after.
Okay.
You can, and typically people do assign the power of attorney. They're the same people as the trustee,
yes.
because it's so much easier
Of
that
course.
way. But you don't necessarily need to do it that way. You could have two people kind of checking, checking balances, right?
Well, my brother has my best interest at heart.
Yeah.
Next to my parents.
Mm-hmm.
So so if I was in a, God forbid, a major car accident and I'm in a coma, I'm in a vegetative state,
Mm-hmm.
he would be able to sign, which I already have, part of the trust package you gave me
Yes.
was a medical directive.
Yes, so that's different. So included in the basic living trust package that I offer clients is obviously the living trust, a pour over will, which after me explaining what a will is, which doesn't avoid probate, you think, well, why do I need a will, right? Well, in order for that living trust to actually function, you have to put assets into the living trust, right? You have to change the title of the assets. That's a term that we call funding, right? So you have to fund the living trust with your assets. In your case, you had a home. So what we did was we changed the title, the deed. We changed it from Shannon Langhorne, right?
Yeah.
A single woman,
Yes.
to Shannon Langhorne Trust. So that's
sure did.
how we,
So upon death, or being disabled, it would be, so it's not fought over, or it's not per se taken away from her and used for medical bills or anything like that. Is that what it does?
that's a whole different issue. Like, for example, if after the age of 55, you're in an assisted nursing facility, and you own a home, it wouldn't disqualify you from Medi-Cal services, right? You would still qualify because you can't qualify if you own a home. But I don't know if you've heard of the recovery lien that Medi-Cal can go after.
What is that?
So if they've actually helped you with nursing homes, or, there's certain criteria of things that they can help you with, right? That they can actually recover from your estate if your estate goes through probate.
Okay.
With a living trust, you're avoiding that because it's not public. And a living trust is one of the exemptions that Medi-Cal has, that if you pass your estate, if you pass your property through a living trust, then you will not, incur that medical recovery, Medi-Cal
Is that what I
recovery
have?
lien. Sorry.
Did I do that?
Yeah. So
Yay.
you protected yourself
And does
for
does
that.
it make a difference if it's revocable or irrevocable?
Ooh, good
Can
question.
it be?
Yeah.
Should
Edward,
it be
good question.
irrevocable so they can't go back
No,
5 years or anything?
that's the beauty of it, is that it changed in 2017.
In
where-
California alone.
Yes,
right?
in
We're
California.
Strictly speaking to California.
Yes.
Okay.
I'm only licensed in California,
Okay.
so strictly speaking, California. It doesn't matter if it's revocable or irrevocable.
What's
It's just so that you know the difference.
Please tell us the difference between revocable
I
and
like
irrevocable
to
trust.
describe my living trust. What I do is that I have this really beautiful box. It's a jewelry box, and it has a key on top. And I tell my clients, assume that this is your living trust. As you could see, it's a jewelry box, and it has a key on top. You have that key to that jewelry box. And what do you put inside of that jewelry box? All your valuables. Everything that is $150,000 and above will go into the jewelry box. Because you have that key to that jewelry box, and you can open it,
Okay.
put things in, take things out whenever you want, then that living trust is called a revocable living
Because you
trust.
can make changes.
Exactly. You could sell your home in the future if you wanted to. You could refinance your home if you wanted to. But in order to do those things, you have to take it outside of the jewelry box.
And if it were irrevocable, it's done.
If it's irrevocable, it would be a jewelry box without that key on top.
It's locked.
It's locked. So you're giving your future interest of whatever you have on that property, you're giving it already to your beneficiaries. They don't take possession until you pass away, but the interest is there in that living trust.
Why would anybody do an irrevocable trust if you can't make changes?
That would be for people who have maybe more than one property and want to start planning for receiving some social, some benefits from the government. They want to start planning for maybe applying for Medi-Cal or, any other public assistance. And if you have more than one property, I'm not a specialist when it comes to Medi-Cal and that type of law, because there's attorneys that are dedicated to elder law and Medi-Cal and all that,
So they would need to seek a attorney that specializes in elder law.
I can guide them,
Okay.
but
And
why
you have
would people want an irrevocable trust? A lot of the reason is they're trying to plan for that.
Okay.
So they do it 5 years before their retirement, maybe.
Right.
So that they can put their assets there. And if they're in an irrevocable trust, then they don't have to list it on those applications as being assets that they hold.
Can I
That's
still
right.
change an irrevocable trust, or just you're stuck for life?
No, I mean, you can change an irrevocable trust, but you need a court order.
Ooh.
So it's a lot more difficult
Involved.
to do than a
Well,
revocable
see,
trust.
we're going through this with my parents because we might need to put them in a home eventually, which is now.
Yeah.
And I've been encouraging them to put their stuff into an irrevocable trust because this is in Texas, and so the laws are different there. If you put it in there, they don't have a policy to go if they go into the nursing home that's going to cover that. They don't have long-term care, so they have to pay their way.
Right.
And then
So it's
once
just
they
like my
go through all their
parents
money, then they start going after their house, and all
Right.
their properties. And then so once they pass away, that money that you sell, if we were to sell those homes, and it's because it was still in their name, we would owe that back to the state.
Those are the here it's called Medi-Cal recovery.
That's what you were
liens.
talking earlier about. So if we did put it into an irrevocable trust, from what I understand, and they went back, and it was 5 years down the road, when they went in, they still couldn't get that.
If it was here in California, they would have to plan 5 years before.
That's the way it is
Wow.
in Texas as well.
Because Medi-Cal has a five-year look back policy where they look and see if you've transferred any of your assets within the last 5 years. If so, then they will count it against you.
When it comes to, I'm not. I would have to get a tax professional answers, but maybe you can answer some of it. Tax wise, I'm dead. My brother's obviously living. My parents may be still with us as well. Does my brother have to deal with any type of tax consequences when it comes to the living trust?
So the beautiful thing with a living trust, and I'm going to use a husband and wife as an example, right? If you have a husband and wife who have a living trust and they go through me, I would have changed the title from joint tenancy, which majority of us have joint tenancy because our realtors tell us,
That's true.
you should do joint tenancy, right? And so that's just how we have it. We don't even know any better, right? But if you're a husband and wife in California, you really should have your home titled as community property with right of survivorship, right?
Really?
Yes, the reason for that is if the first spouse passes away, you get what is called a step up in basis, which means at the time of the first person's death, the house is assumed to have that value. So, an example, if you purchased the property when the property was $100,000, and when the first spouse dies, the house is now worth $500,000. And then when the second spouse dies, the survivor, right? When that spouse passes away, then you get a second step up in basis, which means if at that point the property is worth $1 million, then it would be assumed that the value of the property is now $1 million. So when you give this property as a gift to your beneficiaries when you pass away, when the last one passes away, and they decide they want to sell the property, then guess what? they don't pay any property gains
Capital gains
taxes
tax on it.
because it will
Wow.
be assessed at the survivor's death.
Why do
That's great.
real estate agents or mortgage agents encourage their clients to do joint tenancy?
Well, they're not supposed to tell them anything.
Oh,
You know,
They're
they
not
really
supposed to
aren't.
advise because they're not a
No,
counsel,
they're not
right?
an
They're
attorney.
not an attorney.
They're not
but
supposed to tell them anything.
the people want to buy a house in a jiffy,
And they
they're going to
trust
take
the
their
attorney. Yeah.
Yeah,
I mean,
so-
I'm sorry, they trust the realtor.
the realtor,
so
and then they're going to trust the escrow, and the escrow is going to say what is going to put on
They're-
on the trustee.
escrow does not get involved in that. I've been noticing a lot of that. It's
Oh.
really mainly just the realtors. They don't know any
The
better.
realtors are supposed to tell their clients seek advice to your
exactly.
seek
Yeah.
advice to your tax professional, but they don't do that.
No.
Oh.
So you go on title as joint tenants. And
But you can
then-
change that.
at any time.
Okay.
Mhm.
You can
Yeah.
change that. Cool. Thank you, Michelle, for that.
So that's
really,
a cool thing, right?
Yeah,
I
that's
mean,
very
Good to know.
very good to know.